and I represented the father in a divorce case in Anderson County Chancery Court. The divorce was filed in late June of 18. The parties separated and child support started being paid in August of 2018. And the decision in this matter was made 2 years and several months in November of 2020. During the course of the litigation, the parties entered into an agreed temporary parenting plan. And that plan, once the father, there were allegations of some cocaine drug use when the parties still lived together prior to the filing of the divorce. The agreed order gave the father 2 days a week in co-parenting time pending passing the drug screen, which he did, and for 2 years period, from November of 2018 till November of 2020, he enjoyed 2 days a week co-parenting with his children. And he had asked for, consistently from the initial filing through the trial date, a 50-50 co-parenting situation. But he had 2 days, not 3.5, but he had 2 days, and then they were to correspond with his days off from work, which was Tuesday, returning the children on Thursday. Well, this was exercised for a 2-year period, and at the trial of the case, the judge took away the 110 days of co-parenting time and reverted it back to approximately, the mother's parenting plan says 90 days, but it's really 61 days. She gave him every other weekend, which he works weekends, and 1 week in the summer, and a day at Thanksgiving, and a day at Christmas, and I believe Father's Day, and there may have been one other holiday included. And while the judge went through the factors in determining the parenting plan, what the judge relied on were factors that predated the party separation for over 2 years. It did not consider the current state of the children and the factors that were in place prior to the trial of this case. And the court cites in its factors a couple of things, and that the mother was economically disadvantaged. Well, the testimony at the trial was the mother earned $21 an hour and the father earned $20 an hour. So, and both parties lived with other people, and the mother lived with her boyfriend and her father. The father lived with his girlfriend. So everybody's living with someone else at the time of the trial. The factors that the court relies on cites cocaine use, again, back a misstep back before the parties were separated, and clearly the father took a hair follicle drug screen, and co-parenting, temporary co-parenting began passing that, and there were no other allegations of any drug use for 2 years and 4 months. So, and the father exercised all of his co-parenting during his days off from work. That allowed him to maximize his participation with his children, and the court just ignores those factors and relies on his missteps, I'm going to say. I mean, he admits he did something, it was a bad marriage. He wasn't around a lot before they separated. He didn't participate in a lot of things. He admits to all that. And yet the court relies on the pre-separation factors almost 2.5 years later to take away the father's temporary co-parenting time, limiting back to, I believe it's actually 61 days, although the parenting plan that the judge signed said it was 90 days. The parenting plan that the judge signed was exactly what the mother had turned in. And the sad thing is it gives the mother total decision-making. So the father, who had participated in the children's schooling, had taken the kids to school on his Tuesday to Thursdays, had helped the kids with homework. The deposition of the teacher, Lauren Neal, confirms his involvement with the children and their schoolwork. I mean, they're 6 and 8, so there may not be a whole lot of schoolwork at that age, but he went to school with them, had breakfast with them at school. And so the sole decision-making allows the mother, she took them out of school and put them in homeschooling, so the father cannot participate with their schooling. She enrolled the oldest daughter, the 8-year-old, in counseling without the consent or even discussion with the father, when the father had insurance benefits that would have paid for the counseling.
Ms. Lay, remind me what the difference is between the 61 days and the 90 days. You're saying the plan said 90, but he's only getting 60 or 61?
If you look at it and actually add it up, it only says...
So the math's not right.
The math's not right, but the judge, that's what the judge adopted as her judgment.
All right.
So basically, we went from 110 days down to 60, 61 days, basically cut it in half. And the father cannot maximize his participation as the statute requires with these children, because it's on days that he works, the every other weekend. Now, the judge makes a statement in her opinion that says it's not fair for the father to have every weekend. Well, there is nothing in the record saying the father ever asked for every weekend. In fact, he's always asked for 50-50 time, and the temporary parenting plan provided on his days off. So I'm not sure where the judge came up with that we'd ask for just every weekend, and that's certainly not what we presented at trial or what the record shows. Now, a couple of problems with the record.
What did you ask for at trial for the
50-50?
50-50.
Always, from the time it was filed 2.5 years prior in 18 to the trial. The opinion was November of 20. So it had always been 50-50 time, and the father had been doing 2 days a week, which is shy of 50-50, but it was on his days off from work. So in the factors, one factor, and I would say it was immaterial, the father did, during his 2.5 years of 2 days a week co-parenting, he did bring the children home from a farm on a Sunday afternoon, and they had dirty shoes, but not on the bottom, it was on the side, and that was one of the factors. And the girl's hair wasn't combed to the mother's satisfaction. And there were, I guess the only other factor that the judge cited was that kids had had some bumps and bruises. Mother says fathers never abuse the children, that's not an issue at all. But one of the boys, one of the twins fell at Dollywood Splash Country and went to the first aid station. But there were some bumps and bruises explained, which the mother admitted she'd had some bumps and bruises during her time as well. So really the factors cited by the court don't justify keeping him from having time with his children, significant and time with his children, meaningful time with his children. So that's his main issue. Now, I also raised some other issues as well. There was an alimony award of attorney's fees, and in this case, and it's uncontroverted, the mother testified, the mother's witness testified, and the father testified that the mother's attorney's fees were gifted by an aunt. So the mother did not expend or borrow any funds to pay for attorney's fees. It was a gifted situation. Yet the court found that the mother was economically disadvantaged, and while there were no supporting factors for a rehabilitative or alimony or a transitional alimony, or certainly no other forms of alimony, she did find that the father was entitled to, or had to pay the mother's attorney's fees. Now, the mother makes more money than the father does. Theoretically, she's at $21 an hour, and the testimony at trial was that she can work as much as she wants to. She teaches online Chinese students, teaches them English. So she says she can work anytime because of the time difference, and it wouldn't interfere with the father's co-parenting, and she could work as much as she wanted to. The father, she has, of course, a college degree in teaching. The father has a high school degree and worked at the post office, and his hourly rate is $20 an hour. So if you look at economically disadvantaged, I mean, it's pretty equal. I mean, there's $1 difference in the pay, and both have the same opportunity to work. So the facts don't really match the findings of the court with respect to the alimony, and the fact that it was gifted, it is even more compelling. And also, according to the local rules in Anderson County, both parties are to list their assets and their debts prior to trial, and we had a pretrial conference. Well, the mother didn't list any debts, and she did not list an attorney's fee debt. So there's no loan that mother got. There's no obligation to pay anything back with respect to the attorney's fees. The father did list attorney's fees that he owed on his asset and debt list. So, but the mother never disclosed any of that. Mother also didn't disclose, and we'll get into that, but so in terms of need, ability to pay, the father really has no ability and received no assets in this divorce to even pay attorney's fees. And they both have, he has a little bit less earning capacity than the mother does. And also, I had filed a motion to consolidate the child support file with the divorce file because the chancellor signs off on all the child support orders. The magistrate hears it, sends it to the chancellor, and she signs off on everything. And so the fact that the chancellor relied that the father wouldn't give mother access to money, he had paid his child support since August of 18 to the tune of over $23,000, plus carried medical insurance on the kids. And there was no, and I had asked that all that be consolidated, and actually did make the chancellor's finding a supplement to this record. And I really don't know why they can't consolidate the two. It's the same case, other than the chancellor said, well, we like to have different docket numbers so we can close cases faster, because child support cases may be on the docket for a long time. So, but there's no acknowledgement in any of this that the father paid his child support pursuant to an court order by a wage assignment from August of 18 through the trial date. So in terms of economic disadvantage,
Counsel,
if you look at the
Counsel,
father's...
Excuse me, before your time runs out, you want to address the criminal contempt?
Yes, there was... And this was a COVID case. We tried under masks during the Supreme Court order, so it was a little difficult trying the case to start with. But yes, the contempt, the rule was asked for. The rule was not explained to any of the parties until the lunch break. During the morning recess before the lunch break, the bailiff told the judge that he heard one of the potential witnesses say to the father, how is she going to prove that? That was the only statement made. Everybody agrees that was the only statement. How is she going to prove that? So I cross-examined the bailiff. He said, I don't know who she was. I don't know what they were talking about. I just heard him say that at the morning break. That's the only testimony with respect to violating of the sequestration rule. The sequestration rule was not, if you look at the record, it was not given to the parties until the lunch break. This occurred at a morning break, and the judge did not prohibit the person saying, how is she going to prove that from testifying? But she found him in contempt. I think this case got off on the wrong foot, and then in terms of the division of marital property, 80-20 on the IRA, there's just a real disproportionate share of the marital assets, which shows the judges was not enamored with my client. And I think it got off. But in terms of the criminal contempt, which is beyond a reasonable doubt, there was no instruction given until after the alleged statement made by a third party occurred.
Your time's expired, counsel.
Pardon? Oh, okay. Thank you. Thank you.
Hear from the appellate in rebuttal. Excuse me, hear from the appellate.
Good morning. May it please the court, my name is Carolyn Gillum, and Catherine Warmbrod is with me. We are different attorneys than the ones that had filed the brief. You had noted on the rules to notify you that. We have filed a notice of appearance. I represent the mother in this matter, the appellee. This case is not a typical, what I would say, week on, week off parenting matter. There were very egregious facts found by this court in the final order. The mother was awarded the divorce due to the husband's inappropriate conduct. She found that he was verbally abusive. He damaged the home, kicking doors, putting holes in the walls. He had a sexual relationship during the course of the marriage. It is conceded that both parties after separation were also living with, but that was prior to the separation. Additionally, there was cocaine use. One of the other major factors was that he dissipated many of the assets. These are very modest assets that they had, but he dissipated especially very meaningful assets, including pictures, the minor children's crib, children's toys and books, and refused to return any of it. Additionally, he did not follow the injunctions, although he noted in the record that he had received them. He did not pay the mortgage on the home. He did not pay the car payments, which then caused them to be repossessed. He did not pay the electricity, which caused the house electricity to turn off on the children. Additionally, he just did very reckless behavior. There were discussions of him using cocaine. He admitted to using cocaine, although it was debated how many times he used cocaine. He urinated on the mother in public. He admitted to anger management issues and did state that he had sought counseling, but did not disclose those in the interrogatories. He also opened a car door and attempted to jump out with the children in the vehicle.
Let me ask you about the parenting time. Do you agree that the order says 90 days, but then when you add it up, it's only 61?
Yes, Your Honor. The math is not correct. I think traditionally how it would have factored is if the father had gotten the children at the beginning of the school day on Friday through Sunday, that would have been right at 90. But instead, he got the children at 6 p.m. on Friday until 6 p.m. on Sunday, which that Friday doesn't really count as a day then.
Okay.
If you're doing the 12-hour rule. In regards to and I'll go in order of her brief, she kind of hopped around. In regards to the division of the assets, one of the primary things that the court covered was that he was not credible in going through the assets and did not follow the injunctions in regarding to the assets. He disposed of a huge list of items despite the mother requesting them numerous times. Batson v. Batson states that an equitable property division is not necessarily an equal one. And I think that is one of these cases. He chose to get rid of many assets, many of which doesn't matter what amount of money you have, you could not replace them. And I think that was highly considered by the court. Additionally, credibility is one of the major things in this matter. The court repeatedly within the findings of fact stated that he was not credible. In regards to, there was another argument regarding the Toyota Corolla and the bedroom set and those being declared separate property. Both of those assets also had debts equal to them. There was no equity in either asset. He had bought the car post-separation and took out a loan for the full amount. She had gotten a bedroom set and taken out an equity line credit card to pay for it. So neither one really had any substantial effect on either side of the line. Additionally, you've got spousal support on the next issue. One of the big keys on that one is that she was a homemaker. She had chose to stay home with the 3 children. She was not able to earn as much money because she wasn't able to work. She had the children the majority of the time. Additionally, she was homeschooling the children due to COVID. And as such, you can't homeschool children, which is a full-time job, and work 40 hours. That is not a reasonable expectation for anyone.
What did your client ask for in terms of parenting time? They asked for 50-50. What did you guys ask for?
The 90.
Okay.
The order that was signed was the order that our
That was
client.
yours, okay.
Yes.
Does that maximize both parents' times with the child?
Your Honor, I think in this scenario, I will tell you, I argued the case that you all set the floor of Nouveau. I was the attorney on that case, and so I'm very aware, this is a very different case. You have some very egregious behaviors that the father did. One of the most important facts, I think, that comes out on that question of maximizing is father stated to the court that at that point, he had only had the kids by himself on a couple occasions. So I would question whether even the days that he did have with the prior temporary parenting plan, he wasn't choosing to maximize his time and spending time with the children. He did not even attend some of his children's birthday parties. He did not attend the twins' first and second birthday parties. The court noted within the finding of facts that she felt that he had a preference towards the older child and was not spending near as much time or with the twins, which I think would have a detrimental effect long-term if he continued that behavior on a 50-50 basis. In the regards to the parenting plan, the court went down a long list of reasons why she ordered it the way she did. Number one was that the father lacked credibility. He had inconsistent statements. He would drink in excess in front of the children. He attempted to jump out of a moving vehicle with the children in it. Evidence was presented that he had returned the children in filthy, unwashed clothes, not bathed, with severe sunburns and unexplained injuries that were not explained to the mother at the time. I believe they were explained at the hearing, but that did not provide the mother any information when they occurred. The father was virtually uninvolved with the party's twins, showing a preference towards the older daughter. His handling, destruction, and hiding of marital assets. He turned off the utilities when the children were living in them. The mother, when she was a homemaker, had to request money from the family for food and clothing because he would not provide income. This was prior to her working. And that the father had never solely been responsible for the children. Even after separation, he primarily relied on his mother and girlfriend to care for the children. Additionally, there was evidence of verbal abuse during the marriage, and mother was the primary caretaker the entire time of the marriage.
What about the contempt issue? Do you agree that the sequestration instruction was not given until lunchtime?
You know, I believe the record reflects that.
Okay. So do you agree that the contempt was probably improper?
I would concede the contempt issue, Your Honor. Yes. In summary, Your Honors, I think the big situation is this is not a week-on, week-off parenting plan. This is not a traditional parents that have both been actively involved. This was one of the parents was found not credible in front of the court. And under case law, the trial court should have discretion, especially when it's determining credibility of parents. And credibility was the primary issue within this court on that final order. Thank you.
Of course, thanks to counsel for both sides. We appreciate your arguments and your briefs on this. next case, please.